Francesco, can you hear me out there?
I can hear you, Chuck.
Alrighty. I found out what my connection problems were the last time. I had a faulty router in the house here, and
Oh,
I thought it was uh, the extender that wasn't working right, and I
yeah.
replaced that, and it was the router to begin with. So I should be all set tonight.
Good.
I'm gonna mute myself here and stand
Yep.
by until we're ready to start. Thank you.
Okay. Thanks, Chuck. Okay, Chuck, I have it at 6 o'clock.
Sounds good, my friend. I see we have several of our commissioners on board here and a number of our faithful stakeholders on board as well. Tonight, we're going to discuss parking, landscaping, screening, and buffering requirements, which we discussed in detail at our last meeting. We're going to quickly review those this evening. Not going to spend as much time on what we did last month as we have in the past in order to get to signage regulations a little earlier in the meeting to allow for a detailed discussion. So unless anybody has any questions of me before we start, I'll turn it over to Francesco, and I'll be in the background and speaking from time to time throughout the meeting. Francesco, thank you for the detailed agenda and the excellent job preparing the slides.
Sure. Thank you, Chuck. Good evening, everyone, and welcome back. As Chuck mentioned, we've got a lot to cover. I want to very quickly touch base about some minor changes we made to our recommended parking amendments based upon the discussion we had last month. And then I do want to review the screening and buffering requirements together. You gave me very good direction at our meeting last month. And so I want to show you what I've come up with and hopefully get your agreement on this approach before I write up the recommended amendment. And that's why you didn't receive a separate package this month, because I really need to confirm all this before I write it up into a recommended amendment or series of amendments. And assuming we're all on the same page, then I'll do exactly that and get that out to all of you. And as Chuck mentioned, what we really need to focus on to keep things moving forward is the next part of the work, which is to review the signage regulations. And I'll talk about needs in that area. With respect to our schedule, we're following our schedule lockstep, and that enables us to complete our drafting of recommended amendments by this June. Now, that being said, there's a whole adoption process that we need to start thinking about, and I'll walk you through what that could look like at the end of the meeting when we talk about our next steps. So very quickly on the parking requirements, when we met last month, we had put a 25% limit on shared parking, and you preferred to leave that up to your discretion as the commission, what that balance should be. So we removed that from the recommended amendment. And then we also removed a fixed requirement for golf courses and left it to the commission to work with the applicant to decide what's appropriate. Not that we expect you'll be receiving a golf course application anytime soon. Okay, so let's talk about our buffering and screening. And as you remember from our discussion last month, there are a lot of issues surrounding the clarity of language and what's required, some overlap, inconsistencies, and there's a lot of work that needs to be done in this section. So what we agreed was that I would improve clarity, remove some sections that you didn't feel were relevant, and then really to take a very close look at our parking lot buffering requirements and landscaping requirements as well. And so we've done exactly that, and I'll walk you through those. Starting with our recommended parking area buffer requirements. This is the text that I've drafted. It basically carries, I think, the best parts of the regulations that you have into it, but really makes it clear as to what is required and what the thresholds are. So I'll go through this. I'll try to go through this very quickly because, as Chuck mentioned, we do want to ensure that we reserve plenty of time to talk about signage. But I want to orient you as to what it is we're recommending and what this looks like. So starting with parking lots, what we're establishing is a parking lot buffer requirement. Now, the language in the existing regs is all over the place, as we talked about last month with respect to terminology. A buffer is used, performance buffer, front landscape frontage strip, screening, and these things aren't well defined. And so what we want to do is, to the extent we can, simplify this. And we're just going to use the term buffer area because it's the most commonly used term in your regulations. And we're going to apply that consistently. So instead of talking about a frontage landscaping strip, we'll talk about a front buffer and describe what that is. And we'll abandon the term performance buffer, which is really a term intended to mean a buffer that incorporates screening. And I'll walk you through that in a little more detail as we go on. But with respect to parking lot buffer requirements, we're setting a threshold. And we talked about this last month, how it's not clear as to when exactly these landscaping requirements should be applied, and we don't want them to be applied to parking spaces for 2 or 3 cars. It's intended to be parking lots. So here I've recommended establishing a threshold of 10 vehicles or more as triggering the requirement for providing parking area buffer requirements. Now, we do still have separate buffer requirements for uses and for special permit uses that would also trigger a buffer requirement. So this is just a question of whether or not the parking lot alone would trigger it. So we've set it at 10 vehicles. The size of the buffer in the table there is, those are existing thresholds and sizes that you have. Right now, it just goes from 0 to 49. And so we're setting that at 10. And then we require a buffer along the entire frontage of the parking lot. And that had been called a frontage landscaping strip. We're calling it a buffer, but we're providing all the same requirements and descriptions as to what's required. So it's the same language, we're just using standardized terminology. And I'll go through this a little bit and then I'll pause. And if anyone has any questions or comments, I'm very happy to receive them and respond as best I can. So I'll just try to continue through the parking area stuff and then I'll take a break. So we talked about, right now you have an interior parking lot landscaping requirement, and it's set at a ratio of a certain amount of square feet per a certain area of parking or a certain amount of parking spaces. And we had talked about it instead just fixing it to the size of a parking area based upon parking spaces and aisles and bays. And so that's exactly what we've done here. So we're requiring landscape islands, and I have a graphic in a moment that's going to help you visualize this. I'll talk it through first. We're requiring landscape islands to be provided so that no more than 14 parking spaces in a row can be provided without being interrupted with a landscape island. So if you're driving down a parking road looking for a space, you shouldn't go past more than 14 cars without seeing an island on your left or right. So that's in one dimension, that's parallel to the aisle or and perpendicular to the parking spaces. In the other dimension, we require parking islands so that no more than 2 contiguous parking bays. And you think of a parking bay, it's an aisle and it's the cars on either side. You can't have 2 of those in a row without being separated by an island between bays. So that's the standard. So it moves away from kind of a vague area requirement that requires someone to then design something that incorporates all the landscaping within an interior island, but may not achieve the aims of this, which is to break up large expanses of asphalt. By example, if they were to provide one island in one corner and that's all the square footage and everything else is large area pavement, it's not as effective. So we're providing a standard that really requires very much the same in terms of amount of space, but we're providing more guidance on how it should be provided. And then this is also makes it a little less calculation based. It's just a little less math. You just need to count to 14 or count to 2, and this can be made to work. Furthermore, the other part of this requirement is that any row of parking have a terminal island. That's an island at the end of it that separates it from the cars driving by and an access aisle or road. And that's pretty common to see, but here we spell out that requirement specifically for any row of cars that has 5 or more spaces. So combined, we brought in your existing regulations requiring each island be a minimum of 9 feet, 300 square feet, et cetera, planting requirements and all of that. And then we've kept your tree planting requirements as well. And so we brought that into a new format. And this is what it looks like in application. And this graphic would be provided in the zoning document to help people understand what's being required. So you wouldn't be able to have, and I trust you can see my cursor. I'll use this new laser effect that I discovered, laser pointer effect. So you wouldn't be able to have a parking area that's bigger than this without being interrupted with landscape islands and trees, because you do have a tree planting requirement. And so that's what we're after. And I see Fred has his hand raised, and Fred, go ahead.
Is each of those 14 space a parking bay? Is that what you mean by a parking bay?
These are spaces, and the bay, a parking bay is the aisle with the spaces combined. And we'll need to provide a definition of bay so it's clear.
Okay. Okay.
What we're showing here are 2 parking bays. So you have one bay that has an aisle and has spaces on either side. And then another bay has an aisle and spaces on either side. And so you can only go 2 bays wide or 14 bays. And this is a fairly exact square, roughly 120 feet square. And that's the maximum area. Outside of that, you need to provide islands. So this ensures that you get the interior landscape islands, but it controls the design of it to some extent to ensure that you have some regular landscape islands and tree cover and canopy cover. And then these are the required separator islands at the end of a row of parking to separate it from adjacent aisle or roadway. And this is pretty common in design anyway, but on a job that's where they spend a little less money, they'll just paint these out. They won't actually provide a landscape island.
Okay, thank you.
Okay. Are there any questions or comments about this approach? It's really just migrating what you currently require into a slightly different organization that is a little more prescriptive, but may actually be easier to figure out, because then you don't have to run math on calculating all the areas of the islands and doing the ratio. It's very simple in that way.
It's an excellent graphic.
Okay. Anyone else, any comments or questions on this approach? Okay, good. Let's keep moving because we still have a lot regarding buffers and screening. Okay, and we have one more item on parking. And here we're just taking all your drainage requirements. We're going to put them in one place. So these are the same standards you currently have. You require drainage calculations and drainage plans and various other standards and requirements. All this information is kind of scattered. And so we're going to put it in one place. All the drainage requirements that are specific to a parking lot is one place here. We got rid of some of the references to technical standards, like as to how rain garden drainage swales should be constructed. And we instead point to the Town of Stonington Technical Standards document, which has all the drainage calculations and requirements. So we get rid of some of that technical stuff, and we just point to that standards document, which we agreed on last month as the appropriate approach. Okay. All right. So let's talk about buffering, screening, and landscaping requirements. So what we agreed upon last month is to really create a new section and consolidate everything in one place as best we can. These requirements are currently scattered throughout your zoning regs. Each zone or district has its own buffering and screening requirements. And some of your newer districts like the HI 60 are far more developed. And so we agreed that HI 60 provided some pretty good standards and guidance. So we tried to use that as the model to come up with buffer and screening standards that could be applied across the town, and instead of varying it radically from zone to zone. And we also, as best we could, consolidated all that into a summary table and standardized things as best we could. So I'll walk you through that. First of all, on your definition, there's the existing definition of buffer. We recommend just some slight changes to that to make it a little more relevant. By example, odor, you can't really control odor with a buffer. So let's get rid of the things that it can't do. It's not very good at noise either. Screening in the form of wall is good at noise. Plants are not very good at noise attenuation. So we'll update it to describe what it actually does and what it's capable of doing. So we'll update that. And then screening as well. There's a lot of overlap in your existing definition of buffer and screening. They sound very much like the same thing. And so we want to distinguish what screening means. And screening means something that really blocks visibility. It's a visual barrier, and that's what it does. And it's comprised of vegetation, berms, fences, walls, or a combination of them. But screening is a little different than buffering. Buffering you could still see through, potentially, depending on the density of planting and the time of year. Screening is intended to be a year-round visual barrier, and the two can be used together. You can have screening within a buffer, and so we lay that out and describe what that potentially looks like. So your existing requirements are all over the place. You have required buffer area width, and it goes from 0 to 100, depending on the zone you're in. And also, I showed you some similar tables last month. It depends what the use is next to, and it just bounces all over the place. There's no rational approach, and there's total lack of consistency. And so we wanted just a more rational, standardized approach that doesn't. We don't want to eliminate any requirements. We just want to standardize them so it's easier to understand, easier to apply, easier to enforce, and also more realistic. A 100-foot buffer, if that buffer is intended to be filled with plant materials, you could spend $2 million on landscaping with a 100-foot buffer. So we need to rein in some of these values to something a little more realistic. So this is what we're recommending. And I've got a few tables that look like this. I'll go through them one by one. First of all, what I did is I did a little bit of homework to figure out in which zones where we really have most of the need. So a lot of our buffering requirements require uses in a certain zone to be buffered against an adjacent residential use or residential zone. And that's the biggest trigger. You have a special permit use or another type of use. And if you're next to a residence or a residential zone, you need to provide a buffer. And the question is, how many properties really does that impact? And what zones is that most needed? And what we see is the bigger the number is, the more relevance the buffering requirement has. So the CS5, the LS5, the GC60, MC80, and PV5. That's where you have all of those abutting properties abutting residential zones and parcels. When you're in the TC80, you've got only 6 residential parcels abutting 1 residential use. So these buffering standards are going to be far more applicable and relevant to some zones than others. All right, and I've highlighted all those going forward where they're really going to do the most work. So let's look at that. So once again, these are the ones where we have the most instances of properties abutting a residential use or property. And these are your commercial or industrial zones. The red is what's recommended. So we've got values, buffering widths, and this is the width of the buffer, the distance, perpendicular to the property line where the buffer is required. That range, as I said earlier, from 0 to 100. So we want to standardize that. So in the smallest lot districts where the requirement is 0 or 15, let's just make that 10. And then in those larger lot districts, let's make those 25. And then in some districts, we'll keep it at 0, like the PV5 and the HM, where you have these tiny lots that are built out with 0-foot setbacks as it is. And so we won't touch those. And then, so that's your buffering against it's a commercial or industrial use adjacent a residential use in a non-residential zone. And then the other half of that is when you have a commercial industrial use adjacent to a residential zone. So we have buffering requirements for residential uses that are in a non-residential zone, of which you do have instances of that. And then you have buffering requirements from any residential zone. And so what we see is the buffering requirements from the residential zone are higher. And that's how they are in your existing regulations. They tend to be higher where you have a 0 requirement next to a residential use. You require a buffer next to a residential zone. So we maintain that approach. And so we range from 20 to 50 foot, and we maintain the existing 10 foot in the PV5. So wherever we've struck through the value, we're replacing it with what's in red, and we've maintained some of the standards like in the PV5, MC80, and GC60. Okay. Does that make sense? So we're turning some zeros into a small buffer requirement, but we're reducing some exorbitant requirements like 100 feet down to something that's more realistic, like 50 feet. We're trying to meet in the middle here. Okay, any questions on this approach? I've got a little bit more to this effect, but I don't want to get ahead of all of you.
I think this is what we discussed.
It is. Okay. All right. So if we come out of this and we're all in agreement, then I'm going to put this in writing in a memorandum format and I'll distribute to all of you. Okay. So the recommended buffer requirements for residential zones, we lay it out right here. And so within your residential zones, you do allow some commercial or industrial uses by special permit, depending on the zone. And there's not many, but where those are allowed, you typically allow. I'm getting feedback from someone. Okay. All right, there. So where those are allowed, you currently require a buffer. And so we want to, once again, try to standardize that. Smaller lots, smaller zoned lots, or zones with a smaller lot requirement would have a lesser buffer, and those bigger lot requirement zones, a bigger buffer. So on the left, a commercial or industrial use adjacent to a residential use in a non-residential zone. And here are recommended buffer areas from 10 to 25 feet. And then a commercial or industrial use adjacent a residential zone. And so we range from 20 to 50 to 10, okay? And that's just let me go back. This is a cleaned up version of this, all right? That's what it looks like if we were to put it into the zoning regs. And you can see some consistencies across the board now. Now, your floating zones, they also have buffer requirements. And for the most part, I recommend just maintaining those existing requirements. In the IHRD, you have a non-infringement requirement which which applies to several of your other zones. You require that the commission determine the buffer width. And so these are all existing. And then otherwise in all these other zones, it's 25-foot buffer. So I think the work to be done here is to figure out whether, we should just pick a standardized buffer requirement for the IHRD as well. Otherwise, we could maintain that. Now the residential zones, and I kind of jumped ahead earlier with the other table. So here are the residential zone buffer requirements. These are existing requirements. You do require non-infringement distances. And as a reminder, non-infringement means you can't build in that area. It's like a sort of a setback. And your required buffer area width for special permit uses ranges from 0 up to 50. And what we've recommended doing is standardizing that and maintaining your non-infringement. We won't touch that, but standardizing these to really kind of meet in the middle, and we'll have a range of 20 to 25 to 30 for these buffer requirements. And these are special permit uses. Now, right now in the GBR 130 and RC 120, there's no specified buffer requirement for special permit uses because there are very few special permit uses allowed in those zones. The buffer requirement is kind of attached to the use. And instead here, we can just standardize it. We can just say any special permit use in one of these zones shall require a buffer of this distance. And then we don't have to, for individual uses, specify what buffer they need to provide depending on what zone there is. We just standardize it. Any special permit use requires a buffer. Depending on the zone you're in, that buffer varies in width, and here it is. And so this is a scale that's sensitive to the size of the lots in these zones. Right, and these numbers are fairly consistent with what you have. All right. Okay, I'll move on. Okay, you also have, and this was a tremendous amount of work to untangle all this, so I appreciate you being patient with me as I try to explain it. You have use-specific buffer requirements. So in addition to certain zones having requirements, permit types like special permits having requirements, you've identified specific uses that you require to provide a buffer regardless of where they're located, or in some cases, depending on where they're located. So on the existing is on this side, on this column, and the proposed is in red here. And we're trying to establish, once again, something that's a little more consistent with a 20-foot buffer more consistently required instead of ranging from 5 to 100 as the current requirements do. And going down the list, duplex, it's right now 15 to 50, and let's just set it at 15 and reduce it in the RH10 because of the size of the properties and the purpose of the zone. And food processing will keep the same. We'll establish a 20-foot buffer requirement for any residential use in a commercial or industrial zone. Attached housing, we'll just lower that from 35 to 20. We'll apply it wherever attached housing is allowed, and we'll maintain the 0. Right now it's 0 on the PV5. Congregate living, we'll just set it to the buffer requirement that's equal to the special permit requirement for the zone because they all require a special permit. So that will be the threshold for it. We don't need to establish a separate requirement for congregate living. And that requirement varies from 20 to 30 feet. Open space development will reduce it from 40 to 20. A dog daycare training, we'll just set it at 20. And detached, we'll keep the same. Okay. All right, I'll keep things moving. And then we'll create a new section for buffer area standards that puts everything in one place instead of being scattered across the document. So that'll be section 12.12 that does not currently exist. And first of all, we'll maintain the authority that you have to require an applicant to substitute certain plant materials or provide additional screening. That's authority that's already in your zoning regulations. We'll maintain that. We'll put that at the top of the list so that you continue, while we're trying to standardize requirements, we'll continue to allow you to have the authority to require something a little more substantial if the conditions call for it. All right. And then going down the list, we'll establish a planting requirement. This comes out of the HI 60. These standards, we use slightly different units of measure here. So the numbers look a little different, but it's the same approach, which is instead of saying that a buffer area shall have some landscaping and some planting and some trees and all that, and then no one really knows what that means and how many and what the quantities are. We just established a basic quantity by 1,000 square feet, which is a pretty standard unit of measure. We say you have to at least provide 1 canopy tree, 2 understory trees, 10 shrubs, 2 evergreens. And this follows the model of what the HI 60 does. And then we provide all the conditions, the caliper, 3-inch caliper. We specify how big the understory evergreens, shrubs need to be, require perennial grasses, ground covers to be used at the edge where visible, require bare soil to be mulched. So we put all the design guidance in place so that when you have an application that comes before you, they have the guidance they need to meet your standard, and you're not sending them back because they're not anywhere close, ideally. And that's what this looks like. So this shaded area is 1,000 square feet. And when you take that planting requirement and you put it on the ground, this is what it looks like. You could get a little more dense than this, but it doesn't provide you that much more value. And if you plant plants too close together, they don't do very well. They don't have room to grow and they're competing. So here's our canopy tree, our evergreens, our understory trees, and then our shrub planting requirement per 1,000 square feet. So this requirement ensures that you get a sufficient density of planting, that you get a variety of planting, and it at the same time allows the landscape architect or landscape designer to still have flexibility in the design because they don't have to put these exact plants all in the same spot per 1,000-foot rectangle or square. They can distribute them as they want and bunch them in some areas. So it allows plenty of flexibility. And it's very easy to quantify whether or not the applicant has met the standard because you just calculate the total buffer area required, and then you can figure out, well, how many plant species, how many trees, shrubs, etc. they need per that area, and they can demonstrate that in a schedule or a table. So it's a very simple approach, and is used for the most part in your HI 60 without the benefit of a graphic. And once again, we would embed this graphic in the zoning regulations to help provide guidance. Okay, any questions on that? All right, good. Okay, let's continue. Buffer area standards. So in addition to ensuring that you can require more of an applicant or you can require or demand replacement of materials, we also want to make sure you continue to have the authority to reduce the requirement to be sensitive to the context. And you may have conditions where there's healthy, mature trees and natural vegetation, and you don't want to require someone to essentially replace what's already working for the site. Or there may be topography or other site features that really negate the need for a buffer. And so you maintain that authority to allow for a reduction. So that's a very important part of this. And that allows these requirements to be flexible and sensitive to the site because every site is different. Now let's talk about screening. There are a lot of mentions of screening and screening requirements, and the guidance on that is somewhat scattered across the regulations. So here we're going to put it all in one place. And when we talk about screening, as a reminder, the idea is a visual barrier that blocks any light and views into or out of a property. And so what we define screening as is any combination of berm, fence, masonry wall, dense evergreen planting, at least 4 feet in height. That can be used in combination with a buffer or within a buffer. Yeah, so we provide all the specifications here, and then we require any parking areas over a certain size or for a certain type of use to provide screening to prevent headlights and that sort of thing from traveling onto an adjacent property. All right, so we have 2 features here: buffer area, and that's really intended to soften the edge of things, and screening, and that's intended to completely visually block anything unsightly. And that could also extend to dumpster areas, utility areas, etc. And so to get into that, here are some of the conditions where we would recommend or require screening. You currently require screening for drive-throughs, minor accessory buildings in a setback, small wind energy, service areas, and small solar energy collection systems. You don't have anything. You asked me at the last meeting to include a screening requirement for those, so we have done that. And so what we recommend is maintaining most of the standards that you have, and then adding a screening requirement for small solar energy systems. And obviously, you're just going to do lower level screening in that context. You can't screen too high, otherwise you're blocking solar access. All right, any questions on screening requirements? Okay. All right, so let's talk about some of your floating zones, because these are all unique and special areas. For the most part, we're just going to maintain the regulations that you already have. However, what changes is that we don't need to provide all the standards that I just reviewed as to what a buffer needs to be constructed of and what screening it needs to be consist of. We don't have to restate that each time and inconsistently across each of these zones. We can just say what the requirement is and then point to the standards in our common buffer and screening section in the new section 12. So that's going to cut a lot of excess material, reduce the page count a little bit, and make things more consistent as a whole, which is a good thing, without lessening any of your requirements, just standardizing them. So in the IRHD, we continue to require buffers. You continue to require non-infringement area. And we just, as needed, we point to the appropriate sections of the regulations where you can find those standards in more detail. In the MHD, we require, or we have it set that the commission may allow for buffers or screenings to be partially located on adjacent property with consent of affected property owner. That is already allowed, so we continue that. We maintain the 25-foot buffer, and we also allow them to be reduced in width here as well, because you've got there's a little nuance to this that's specific to the MHD. So we maintain that. And then moving on to the NDD, we also maintain the 25-foot buffer. There's a little bit of nuance in planting width and planting density, so we keep your discretion in that. and we maintain a non-infringement area. So there's not a lot changing for these floating zones. We're really just removing a lot of that common language and putting it all in one place, instead referencing. So as you can see here, we say, a buffer is required and shall be installed as specified in section 12.12.1. Well, that's our new section. And prior to that, there was a whole paragraph or two here that talked about what was required. And that same information was repeated in another floating zone. All right, let's continue. The GDD. And here we do recommend a change, which is to rein in some of those buffer area widths from 100 feet to 50 feet in the front yard and 50 feet in the rear or side yard. It's currently set at 175. And 50 feet's a lot of buffer, and particularly with our planting requirement. So I think it will continue to serve you well. And then there's also a minimum 10-foot of screening requirement, but that screening requirement really isn't sensitive to what's actually on the property. Presumably you have to screen even if you have just landscaping on the property. So we want to fix that screening requirement to actual things that could cause a nuisance and that require screening, like parking and dumpsters and utilities, and fix it to that. So by getting rid of the screening requirement here, we're not eliminating or preventing screening the GDD. We're just fixing it to the things that require screening instead of making it a universal requirement. Okay, but we maintain the buffer area requirement. Okay, I'll keep going. And the AHD, we pretty much keep this same as well. This is the same language. We maintain it. So there's no real big changes here. And then that's the second half of it. So no big changes to that. Okay, additional recommendations. So we want to standardize the language. So wherever we refer to a buffer yard, we want to call it a buffer area. The term buffer area is more commonly used in your regs. Buffer yard is occasionally used. The trouble with that is it starts to confuse it with required yard, and they're not the same thing. So we want to avoid any confusion with required yard, which is a setback. We want to change item B below, and that's commission powers relative to action on a special permit, and then which allows you to set extra buffer requirements. As currently written, it says between 25 to 100 feet. And we want to allow you to require an additional 5 or 10 feet of buffering if that's what's appropriate to the situation. So we're just going to unshackle that lower end and just make it up to 100 feet. So this is just making things a little more flexible. All right, so that's it for buffer and screening. Are there any questions or comments on all of which I just reviewed? And I realize it's, like drinking from a fire hose here, but now would be a good time to voice any concerns or throw any questions you have at me. Okay.
I think you did a good job in getting your arms around a lot of the discussion that had unresolved issues particularly in the buffer area.
Yeah.
And the tables are very helpful, and putting it all in one place as opposed to having it spread throughout the regulations makes it much easier to understand, much more concise.
Good. We want to ensure that these are enforceable, in that you're not constantly having to waive requirements simply because the requirements are excessive or complicated and the applicant just can't get their head wrapped around them, and neither can you. And so you have to waive something just for the sake of moving things along. We want to make this as straightforward as possible and setting you up, everyone up, the applicant and you up for success with respect to having standards and requirements that are reasonable and fair and yet remain effective for the purpose as intended. Because what I heard overwhelmingly was that these things just aren't enforced or implied or routinely applied. And we want to move towards something that is routinely required, applied, and enforced. Okay. All right. I'm glad we got that behind us. So I'll take all of that. I'll go ahead and package it up into a series of I'll try it as best I can to get it all into one recommended amendment memorandum. I'll just treat it all as one section, but there's some stuff in the other parts of the document we might need to handle in a separate memorandum. So I'll sort that out and I'll get that all to you in advance for our next meeting. Now let's talk about your sign regs. So before we actually get to work, I have like a little bit of a course that I need to conduct on Supreme Court, a very important Supreme Court case. And so this was Reed versus Town of Gilbert, dating back to 2015. And this is really big in the signage and the zoning community, the sign zoning community. There's a very good organization called the Sign Research Foundation. This document on the right was produced by them. And I often refer to their materials and their research. It's very helpful. They provide a very good summary of this case, which I've extracted from. Essentially, this case was it's a freedom of speech case about what you can and can't put on a sign and what a municipality can and cannot regulate. And what the Supreme Court ultimately decided is that signage regulations through zoning should be content neutral, meaning they should concern themselves with how big the sign is, how many signs there are, what the sign's constructed of, whether or not it's a visual distraction, nuisance, there are any health or safety risks, and that sort of thing. Everything that zoning is really intended to cover. And that zoning should not concern itself with the message that's on the sign. That's really at the heart of this case. So I'll walk you through that. I've got about 3 or 4 slides to explain this. So in 2015, Supreme Court ruled that a regulation that on its face requires consideration of the content of a sign is considered content-based regulation. And will be subject to strict scrutiny, which means the courts, whenever they see that, they're gonna pull it apart. A regulation that is facially content neutral, meaning you just look at it and it appears content neutral, could still be considered content-based if its actual purpose, if its intention is trying to control the message on a sign. So you have to be genuinely content neutral in your approach. A content-based sign regulation is presumed to be unconstitutional and will be invalidated unless government can prove that the regulation is narrowly tailored to serve a compelling governmental interest. And this is known as the strict scrutiny case or test. And a compelling governmental interest is really the zoning authority that you have, that the state of Connecticut grants to you. And that's it's a pretty big list, but central to it are the reduction of nuisance, the preservation of property values, the health, well-being, welfare of the community, et cetera. So that has to be at the core of any sign regulations, are those fundamental zoning authority. And continuing on. So because the Reed ruling considers speaker-based provisions to be content-based. So when we talk about speaker-based, we mean who is providing the message. Differing treatments of signs for educational uses by example, versus institutional uses versus religious institutions would be subject to strict scrutiny. So the courts do not want to see you developing sign regs for these different types of uses because there are potential discriminatory suggestions or implications when you do that. So they will make any of those regs subject to strict scrutiny. And what that means for you as a community is that it's very likely you go by another 10 or 20 years with your existing sign regs and it will continue to serve you and won't be an issue. But really all it takes is one lawsuit in Connecticut Superior Court, and the courts will then pull your zoning regulations apart, and the town will be subject to a lawsuit. And if your regulations are found to be in violation of Supreme Court ruling, then that suit will likely be successful. So continuing on, Reed does not, however, cast doubt on the content neutral time, place, or manner regulations that are the mainstay of almost all sign codes, provided they are not justified by or have a purpose related to the message on the sign. So that means you can still restrict the time that a sign, the time of day that a sign could be turned on, by example, where it can be located on a property, the manner in which it is constructed or displayed. You can still regulate all those things. You just have to be agnostic as to what that sign is being used for and what the message on it is. Okay, so the court provided an example of some rules that would not be content-based. So that means these rules would be okay because they're not content-based. Regulating the size and location of signs, including distinguishing between building and freestanding signs, distinguishing between lighted and unlighted signs, between signs with a fixed message and electronic signs with messages that change, distinguishing between the placement of signs on private and public property and between the placement of signs on commercial and residential property, restricting the total number of signs allowed per mile of roadway, distinguishing between on-premises and off-premises signs, and imposing time restrictions on signs advertising a one-time event. So you can continue to do all of that. All right. So what I did is I reviewed your sign regs, and they're actually very good. And I don't think it's going to be a lot of work to remove the content-based regulations. And I also don't think that by removing those content-based regulations, we're going to significantly change the way you regulate signs or what's allowed in Stonington. So those are all good things. So for each one of these sections and subsections, if it is not content-based, if I saw no conflict at all, I put a green check by it. And so that the first 2 pages of your sign regs, it's all fine as is with respect to being content neutral. I'm going to go through the regs 2 pages at a time here for this, looking for this issue. And once we get through that, I'm going to stop. And then I'd also want to make sure we have an opportunity to talk about additional needs that you have with respect to your sign regs to better understand what is working and what's not working, where they need to be more restrictive or maybe be more permissive. So I don't want to suggest our only work here involves removing content-based regulations. We also have an opportunity to better shape these regulations to serve the community's needs. So I want to be thinking of that as well. I just want to get this content-based stuff out of the way first. Okay, where we run into trouble is in section 14.5, where just about every sign type is fixed to, once again, the speaker or the purpose, or makes references to the potential content or message on the sign. So when we say real estate sign or contractor sign or temporary residential development sign, those are all specific to the content. And so we need to change the way we do this. In a nutshell, the way we do it is we instead focus on the use and the construction. So a real estate sign and a contractor sign are really the same thing. They are freestanding temporary sign that's stuck out in the yard to advertise a business. And so the way we handle it, we just call it a temporary yard sign. And you can put some controls on how many and how big they can be, how long they can be out there. So we can still regulate this. We just need to get rid of these individual purpose or uses or references as to who's putting the sign out. So going further down the list, directional signs, historic plaques, identification sign, political campaign sign, community event sign, seasonal agricultural sign, farm sign, home occupation sign, institutional sign. We want to get rid of all those. What we can keep are incidental signs, special use permit signs. We can have standards attached to any special use permit because it's really just about the scale and intensity of use. It's not about whether or not it's a church or a school or a business. And then section 14.7 is actually in very good shape because that's focused on the type of sign and the construction of the sign and where it's located. And so all that content is very good. We have building mounted signs, wall signs, special wall signs, awnings, projecting window, open flags, detached signs. On detached signs, you regulate the height, the screening. All of that is completely acceptable as it currently stands. So there's really no changes necessary. And most of the content in 14.7.3, which regulates your detached banners, we just have a little bit there. You talk about the use of some banners in item C down here, banners promoting a specific public event. So instead, you just be a little more generic, any event, banners promoting any event, and then 45 days. So that's very minor. And then as we continue on, 14.7.4, internal use signs, that's all fine. Temporary detached commercial signs, that's all compliant. All of your multi-tenant signage program is fine because you're not talking about individual sign types. It's really just about packaging of signs. Municipal athletic field sponsorship panels. I think the only change that's required there is just to call them panels. So get rid of sponsorship and just call them panels. And then we look at the permit requirements. These are all the terms that I reviewed earlier: contractor sign, directional sign, historic plaque. So we can get rid of all those terms and replace them with things like temporary sign. But you can keep all these regulations, whether it's as of right, a zoning permit, who approves, is the ZO, is it you, the commission? We can keep all that in place. We just need to change some of this terminology. So here's what I recommend. And anything in black ink, it stays more or less as you currently require it, and in red is what we're recommending. So real estate contractor, temporary residential development sign, we just call it a temporary detached sign. These directional signs and historic plaque and public purpose and ID signs, we just call them incidental signs. And you can have rules about how many are total square footage, whatever it may be. You already have something called an incidental sign, so we're using common language that you already have in the zoning regs. We're just going to take that and apply it, put more under that umbrella. A political campaign sign, a community event sign, seasonal agricultural sign, those would all be called temporary detached signs as well. Farm sign, we just call it a detached sign. Detached signs would stay as detached signs. and temporary detached commercial sign, just temporary detached sign. So it's really just organizing this a little differently, but it's the same set of regulations that we could maintain and still be compliant. I also recommend that you just outright exempt certain signs. Now, generally speaking, the zoning regulations, you apply regulations to sign types that you identify. But it's also beneficial just to say, hey, these signs that they don't need any review. All right, these are by right. We just totally exempt them. The zoning regs are not intended to apply to these signs. And that would include any legal obligation signs, federal, state, or local law. By example, your zoning regs require an applicant for a zone change to post a certain amount of signs. And so anything like that would be allowed to, would be exempt from your sign regs. Internal signs, zoning regulations typically don't ever regulate signs that are internal and not visible from the outside. Traffic signs, would just exempt those, anything authorized by a traffic authority or the state or the manual of uniform traffic control devices, which could sometimes be required on a private property as well. We'll just exempt those out. And then government signs. Okay, does that make sense?
Yes, I think it does.
And Fred, I see you have your hand up. Go ahead.
I do. We have smaller governmental organizations called fire districts, and they sometimes have their own signage. The one I live in particularly, but perhaps others. So I think you ought to include fire districts
Okay.
as an item.
Fred, what type of signage are you thinking of? Just like their sign for the station, or are you thinking of like them promoting some sort of event, like fundraising event or breakfast or something?
No, they're things like well, speed and that sort of thing, and stop signs and that sort of thing. But there's also private property signs, no trespassing signs, no. I mean, there's a range of them that
Yep.
perhaps ought to be recognized. I'm not sure if it's true of other fire districts or not, but it's certainly true of this one.
Okay, so because the fire district is located in Stonington, anything within the fire district would still be subject to the town of Stonington zoning regulations and everything else we just reviewed. As far as like a no trespassing sign or signs like that, those would fall under the category of an incidental sign and be regulated in that way. So there would be some regulation. Here, I think your question is really, I think it's most relevant to this last bullet item, which is government signs.
Exactly.
Yeah. So yeah, I think it's incumbent upon you as the commission to determine whether or not when a fire district, fire station wants to add sign, improve sign, replace signage, whether or not you want the authority to review that or not, or whether or not you want to allow them to do that as of right without coming before you or without going to the zoning enforcement officer. I think that's really a decision for you as a community. And as well as this last bullet item, you may decide that you want to see anything that the school district or the town proposes, that you want it to go before the ZEO, or you want it to come before you, and you want to maintain some authority over that. So we don't have to exempt government signs. A lot of communities do, and so I put it out there as an idea here, but we don't have to exempt them. And then if you do decide, yeah, that's something we want to exempt, we trust the town to do what it's going to do, then we could consider also adding local governments such as fire districts as exempted.
I think that would be the easiest thing to do, would be to, uh, allow the fire district the same exemptions as a government authority.
Okay. And so do you agree that you would like government authorities to not be subject to your sign regs?
I think in the categories that you've listed,
Yeah,
specifically like the manual on uniform traffic control devices,
yeah,
yeah. Uh, in many cases, there's no option. You have to put the signs.
You have to. Yeah, that's why we want to exempt it.
So where you have no option, and you have significant liability if you don't conform to the manual on uniform traffic control devices.
Yeah.
I think the exemption is the logical way to go.
Yeah.
I think I'd like to look at the rest of the exemptions before I say that
Okay.
I'm comfortable with all the rest of them, but we can revisit that perhaps at the next meeting after everybody's had a chance to
Okay.
think about it. But I think as it relates to specifically manual on uniform traffic control devices,
Yeah.
I think they have to be exempt.
Right. And so I think the first three are very straightforward. Legal obligations, right? So a government, there's a legal obligation to post some sort of sign, right? You can't get in the way of that. Internal signs, you don't have zoning authority, so we just want to make it clear. Traffic signs, you just made the case for it. So I think the real question mark is the fourth bullet, is government signs as a whole. Like, do you want to, if the state is doing something and they're going to put out a sign, do you want to be able to regulate that, or the town, or as Fred mentioned, the fire district? Do you want to make them subject to your sign regs, or do you want to allow them to go ahead and do what they're going to do? I think that's the real question here.
Did you say that if the state is going to do something, because the state is sovereign to zoning and can,
Yeah,
we can't
and this, so we bump up against this as related also to a citing council jurisdiction.
Okay. Yeah.
Where you can establish a set of regs that identifies what the expectation is in the hopes that the state complies with what you're requiring or requesting, and then they're going to do what they want to anyway. So we don't necessarily need to exempt them because they have that sovereignty anyway. But we could specifically make it clear that they're exempted.
Like I said, I'd like to, I think, to have the time to think about this section.
Sure. Okay.
Before I say I'm 100% comfortable with it.
Yeah. All right. So I would consider this to be the only question mark, this last one. All right.
A little homework for everyone online here.
And what I could do is I could come back with examples as to how other communities handle this. And I would say it's probably maybe 50-50 that some communities outright exempt the town and others make no mention. It's one or the other.
Okay. I think that would be helpful.
Okay. Yeah, I can do that. And the same is true of zoning as a whole. Municipalities can exempt municipal projects from being subject to zoning, and some communities do and some don't. So it's really the same principle that applies to signage. Okay. All right. So that brings us to the discussion I was really hoping I could have, is to better understand what the issues or the needs may be with respect to regulating signage in Stonington. And so what I'm interested in hearing is what, in your experience, has not worked well, where the signage regulations need to be either stricter or more lenient, where they need to be clearer or easier to comply with or easier to enforce. And I'm very receptive to anything that you throw at me. And then I can come back to you with a recommendation as to how to handle that at our next meeting.
Open it up to the members that are present and anybody that would like to speak on the subject. I also think Clifton may have some perspective on this question as well.
And based upon whatever discussion we had this evening, I can follow up with both Clifton and Candace. I'm sure she has, plenty of thoughts on this subject, and I think it would be quite valuable to get her feedback on it.
I think it's fair game too for anyone that has an issue that wants to feed back to Clifton with a concern in this area. If we're going to take it up at the next meeting, it would have to be fairly timely, but would invite people that don't necessarily make a comment tonight, but have feedback that they can channel to Clifton to please do so. Maybe we move on and come back to this.
Yep, this is slide 55 already. This is
great. Okay.
This is what remains to be discussed. We don't have anything after this other than talking about where we go from here.
Well, I think we'll move into what we talk about and allow anybody that wishes to feed back to us on this, unless anybody has a concern they want to discuss now.
I have one comment. I don't know if anybody can hear me though.
Yeah, Clifton, go ahead.
I have a question about material or art related signs. Sometimes we get questions from property owners that want to paint their sign as like a mural. How would we go about addressing something like that where it's kind of an artistic approach to signage?
Yeah, you really have to allow it. You
Does it fall under content based?
If you regulate
advertising, say the business.
Yeah.
How do we approach that with the Reed Gilbert case?
So, Clifton, so I better understand your comment or question. You're talking about a sign, right? So you're really just talking about the design of the sign and artwork on the sign. Is that correct?
Correct. It's the question of, can I paint a mural on a side of a building as a sign rather than construct a sign itself?
Okay, so you can regulate that, and what you do is you can simply prohibit a wall sign to be painted directly on a building. You would have to require it to be a separate structure that is removable from the building. You can prohibit that because you're really talking about the construction. You're agnostic as to what the content is, whether it's art or letters or a sign. You don't care. You just say, no, you can't paint on a building. You can also continue to limit the size so that any painting on a building of any message or art or mural, anything other than traditional flat paint, then becomes a sign. You treat it as a sign, and then they are limited as to their sign allowance. So if they are already meet or are already at their sign allowance because other signage on the property, they can't do an additional sign. So yeah, you can outright you can ban murals because you're not banning the message on the mural, and you can treat them as signs as well. So all of that you have the authority to regulate. You just can't, if you do allow murals, you can't tell people what kind of colors they can use. And well, this is all uncharted territory for the most part, because Reed just basically set everyone back onto their own to figure it all out and comply as best they can. And the courts are waiting now, just sitting back little by little across the country, kind of testing testing this hypothesis little by little. So,
Yeah, and
yeah,
I don't want to
so-
be the community that, tests that, but
yeah,
if you're regulating how you're painting the side of a building, what's the difference between that and regulating how you paint your house? And so I
Yeah.
think we get into a bit of a gray area where somebody
yeah,
can come in and say, I want 3 different paint colors on the side of my building. And it just happens to be in this, artistic design format.
right.
Does that fall under a mural? Does it fall under a sign? Does it just fall under painting? We've had this question a couple times, and the
Yep.
commission recently had it on a different application where an abutting property owner didn't want screening against their property because they wanted to paint their side of their building as this kind of like mural thing.
Gotcha.
Even though the regulations said that there was supposed to be screening there, they were requesting that that be waived by the commission so they could paint the side of their building.
Okay. This, I don't want to claim to be the constitutional expert on this. And I think if you ask half a dozen lawyers or planners, you'll get half a dozen slightly different responses. But the common theme will be that you can regulate signs. The state gives you the authority to regulate a sign, and you could consider anything that delivers some sort of message to be a sign. And so you can prohibit signs to be painted onto any building. And that's the way a lot of communities try to regulate or prevent murals, is to outright prohibit any painting. So you have to construct something and attach it to the building. So those are well-tested grounds. When you start to get into the nuanced aspect of it, like this combination of 3 or so colors and some sort of pattern, does that constitute a mural, or is that just painting your house? And if you're outside of a historic district or a village district, you don't have authorities of town to regulate that. That's where we really start to head into the unknown. You can, through your signage regulations, you can regulate the use of color, but you have to do it across the board. And so you could limit colors to 3 colors or all black and white. You have the authority to do that.
We do limit by the opacity, especially on lit signs. So we can definitely do that. I think the commission at some point just needs to make a determination on the murals painted signs component, just so we can have something in the regulations where we can point to. I'm not going to weigh on which way that should go, but I think the commission should weigh in and make a decision on it at the next meeting.
Okay. And going back to the concept of a mural or artwork, and Kim, I see you have your hand up. I'll go to you in just a second here. If someone wants to do a mural on their sign and they're allowed to do a sign, and it's within the sign area that they're allowed to build, that's where you simply don't have authority. Like if they want a mural and there's no letters on it at all, they just want a mural because they sell tie-dyes and they want a tie-dye mural, you don't have authority to not approve that, provided it's within their sign allowance. Okay. And Kim, go ahead. Or Kit, I'm sorry, Kit, I apologize.
It's okay, yep. Maybe I missed it, but how do temporary signs loop into this, such as retailers that put teepees out or whatever you call them?
Yep.
And bring them in
the A-frame signs.
Or real estate signs or, special event, weekly things.
You can continue to regulate those as you currently do. You do regulate signs. You just, in many instances, you refer to them specifically like an A-frame retail sign or sandwich board sign, it's called.
Yeah.
You can continue. We can continue to do that. We just call it. We're just going to refer to them more generically as temporary detached signs, and then you can continue to provide restrictions on season of display, time of day, how many, how big. All those things you have the authority to continue to regulate. You just need to get away from referring to their specific use or suggesting what kind of messaging is allowed on them.
Is there time frame already in the regulations that, you know, if you put it out in the day, you have to
Yeah.
take it at night?
No, I don't think the only time limit I recall having is for event signs that are limited to 45 days. And I don't recall there being a time of day reg. I could certainly take a closer look at that. My general approach.
I'm just
Yeah, go
remembering a
ahead.
couple of years ago, there was a big kerfuffle with
Yeah.
a retailer downtown, the bakery, I think it was.
Okay.
And I'm trying to remember what happened there, but it wasn't pretty, and I don't remember if there were regulations that supported what the town was trying to get them to do or not.
Okay. All right.
Anybody remember that?
I do know of that issue. I don't remember the outcome, but we've basically allowed the A-frame signs to go out during operable business hours. The only time it becomes an issue is if it becomes an ADA barrier.
Mhm.
And so
Yeah.
those are the times that we've pointed it out and said that it's a violation because it's basically on the sidewalk and creating an ADA issue. I think with something like A-frame signs or temporary signs that go out, again, something to consider is, since we can regulate based off time, that we spell it out in the regulations that those would need to be during the operable business hours. And so that way it's equal across the board.
And so your language, and I just pulled up that section of the regs. You do have a prohibition. You require signs to be removed between 11 p.m. and 6 a.m.
Sounds like it makes sense.
For
I
that
also
specific
think, I
type of
also
sign.
think that we sort of left the subject of murals prematurely there, and I don't necessarily want to circle back on it, but I think in the review of it next month, if you could suggest how other towns have handled
Okay.
murals, that would be helpful.
I'm happy to do that. I could tell you that I'm working with Glastonbury right now, and they decided they don't want to allow murals, and so we wrote in an outright prohibition on murals.
Yeah, I'm familiar with Glastonbury, and I
Yeah.
I think reviewing what they did might make sense for us, but I'll leave that up to the board to judge. But if we could circle back on that.
Yeah, I'm happy to.
And I think why don't we move at this point to next meeting and wrapping this up tonight. I don't think there's any harm in letting everybody leave early tonight.
Okay. So Kit, did we sufficiently discuss your concerns about those A-frame sandwich board signs? So there is a time of day restriction currently, and we'll maintain that. Anything else?
No, I was pointing to that one incident, but I do
Yeah.
see a lot of the tent signs going out downtown in particular. And
Okay.
I'm not sure if it's adds to the environment of downtown Mystic, but
And when you say tent, do you mean tent pole signs? Like
no, the sort of the A-frame
the A-frame
signs that
sandwich
they put
board?
out,
Yeah.
I'll
Yep.
call
Okay.
them A-frames.
Gotcha.
Yes.
Yes. Right. Okay.
Okay.
All right. Okay. Anyone else? Anything else? Okay. Well, let's take a look at what's in front of us, because we're getting very close to being done going through the regulations. So what's immediately in front of us, in front of me, is to finalize the buffer screening and landscaping amendments based upon everything that I presented you. And I'll put that into a recommended memorandum format. And then I'll get to work on these sign regs and strip out that content, anything content based. And so we'll have some work to do. There'll be some implications surrounding that, some decisions to be made as to how we handle some of those changes. And I want to make sure we're all on the same board, on the same page with respect to that. So we'll review that in detail at our meeting next month. I've been coordinating with Clifton. We've been talking about this for a little while now, is to conduct another workshop. And I think we only need like one more public workshop to go through. We've done residential zones, we've done commercial zones, we've done environmental regs. We've done a series of workshops. And the last one is this most recent subject matter we've been dealing with, which is parking, landscaping, buffers, signage. And so we've looked at some potential dates, and it looks like April 9th, there is space availability. And Clifton, I have that right. It's the 9th we talked about, right?
Yeah, the two dates that we were able to
Yeah.
set aside and schedule space are April 9th or April 30th.
Okay. So the question is what the commission's preferences are. So the 9th, which is coming up very soon, and we need to start to advertise right away. The 9th, we're still kind of a work in motion here, and we can kind of open this up and get feedback on this as we're working. So that's the benefit of the 9th, and that's a little more consistent with how we've been doing things. Going to the 30th enables us really to wrap up all this work, button it up, get those recommendations made, and then put it out there and use that meeting as a little more of a sounding board. Did we get it right? And are there any fine tuning and adjustments being made? Because we already have some good orientation where we know where we're going. I think we really need to understand is, did we get it right? And then furthermore, the other benefit of holding a meeting on the 30th instead of the 9th is we're just a little closer to getting things figuring out how we're going to actually bring these amendments forward. And we could potentially use that meeting date to lay out that agenda with the public and get some buy-in into the process. Whereas we're not quite there yet. I think we benefit from getting another meeting under our belt before we've got that sorted out. And I do want to, our next slide, I want to talk about what's in front of us. So with all that being said, and I didn't mean to suggest I have a particular preference of dates. I really want to leave it to you, the commission, to determine what's going to serve us best. Our options are April 9th or 30th, and we're avoiding the school holiday with either option. And I'm interested in receiving some feedback on that, as is Clifton.
Sounds like the meeting on the 30th could be much more productive.
I think so. I think so.
I mean, a much better use of everybody's time. So unless anybody, online objects.
I agree with you.
Okay. I think it's a good idea. What distinguishes this work from our prior workshops and our prior content is those were so big and open-ended, big discussions about environmental regulations, protecting land use, and commercial development. This work is a little more technical in nature, and we got
a lot out of the the votes that you took, the polling that you did.
Yes, we did
in those, and I don't see that same. Maybe there's some interaction like that, but I don't see, the same diversity in this subject that we had in those, and so many unanswered questions.
Absolutely, yeah. So I think the 30th could be a really good springboard for moving us into the adoption process or phase of this work, and that's what I like about it.
Agreed.
Okay, very good. So let's do that. And what I think and then, we've also been doing these virtual public presentations. Once we develop our series of amendments, and we could potentially just roll that into a big public workshop, because our attendance at those virtual presentations hasn't been that great. Whereas we've gotten much better attendance at the in-person workshops. So we could just roll that in, and we could use that workshop to review our commercial zone recommendations, which, they're fairly surgical and conservative. So I don't think there's a lot there that's going to get people too worried. And then review, talk about everything that we've been involved with currently. But really, maybe that's the first half of the meeting. The second half of the meeting is about where we go from there and how we get it done. Okay.
Makes sense.
Okay, very good. All right, so what does that look like? So this coming April, we'll put that discuss finding from the workshop to the side, since we'll be doing the workshop on the last day of April. But this coming at our meeting this April, we will review the buffer screening, parking lot landscaping requirements, and then we'll dive into the sign amendments that we prepare as well. And then we're going to start to take a look at the final piece of this, which are your permit, plan requirements, procedures, and administrative aspects. And here we're not reinventing things, right? We're not going to say, hey, we're going to get rid of this special permit thing, it's too much work. It's really about what are the specific requirements? Does the process work correctly? How can we streamline and make it more efficient and effective? So it's very procedural. And do the regulations adequately and clearly identify what's required of an applicant and what the process that's required of the commission or of the ZO or whoever it may be. So it's really about fine tuning, I think. So that's the work that's remaining in front of us once we get through the sign regs and this buffer area and landscaping stuff. So we'll do that in April. In May, we'll come back and we'll review whatever recommended amendments we've made to the permit, plan requirements, procedures, and administrative aspects. And then that concludes our development of recommended amendments. And then it's incumbent to really figure out our next steps and how you want to roll these things out. So what I recommend is in June, that would be our final regular meeting of a 3-year-long process. And what I recommend doing with the June meeting is using it to do a brief review. I say brief, but I realize it's going to take some time, of all recommended amendments. Just a reminder, we'll go through the list. This is what they were. And then figure out an approach. What do we want to move forward? How much do we want to move forward? Where do we want to start? And what does that schedule look like? How soon can we get started bringing things forward for a public hearing and consideration of adoption? How much time would you like to spread that over? How much do we bundle together? And I think that's what we really need to figure out in June. Okay.
I think that's a good synopsis.
All right. And our next meeting is April 23rd, once again at 6 p.m.
Outstanding.
Okay, that concludes my presentation. Chuck, anything in closing?
No, I certainly appreciate we have a good following here. Many that attend our regular meetings, and some that just follow these. But it's I particularly appreciate Fred Dykman, a past commissioner, Carlene, who's been with us all the way, and everybody else that attends, all our regular members of the commission and the alternates that attend all these meetings, and all the stakeholders that take time out from their busy schedules to to help us with this process, because it makes it a much better process. So thank you to you all. And I do, and I know everyone on the commission appreciates your input. So with that, unless there's any comment from anyone else, I think the business before us this evening is concluded, and we can adjourn.
Okay, good night, everyone. Thank you very much.
Thank you.
Thank you. Thank you, Francisco. Thank you,
All right.
Clifton.
Thank you.
Good night to
Yeah.
everyone.
Thanks all. Good night.